So today we'll be discussing the patents. So patents is a kind of intellectual property rights. We discussed already in the introductions to intellectual property rights chapters. So let me show you what would be the learning outcomes. The learning outcomes, what is a patent and how is it differ from the trade secret, why patent, history of patenting system, criteria to get a patent, rationale and nature of patent, rights of patentee, components of a patent, international patent classifications, non-patentable inventions and patent filing. So let's get started. What is a patent? Patent is a kind of intellectual property rights that is given to an inventor for a limited period of time. This limited period is only 20 years all over the world. And in exchange of that, a patentee or an inventor needs to disclose his inventions to the society or the government, whatever you say. And in exchange of that, you will get patent protection for 20 years. So that is the basics of a patent. Patent is a kind of intellectual property rights given to an inventor for his inventions or innovations. So what happens if you do not go for a patenting? Somebody else might patent, competitors might take advantage of it, potential licensing, selling, that means economic benefits. You will lose your economic benefits that you could have reaped out of your patenting or inventions. So let us discuss a little bit or a brief touring on this history of patenting system. The first recorded patent for an industrial invention was granted in 1421 in Florence, Italy, to the architect and engineer Filippo Brunelleschi. The patent gave him for a 3-year monopoly on the manufacture of a barge with hoisting gear used to transport marble. Brief timeline of a patent across the globe. Patenting system was not emerged in a day or overnight. History is very old, almost 600 years old. First, it started as an English Statute of Monopoly 1624, and then different countries enacted their patent laws in the different times. US Patent Act was enacted in 1790, French Patent Law 1791, Paris Conventions 1883. Paris Conventions, I'll be discussing later a little bit on these Paris Conventions because Paris Convention has a great implications on intellectual property rights, especially patenting systems and the copyright systems. And WIPO, Intellectual Property Organization, United Nations Organizations Conventions in 1967. And the last one is the TRIPS. TRIPS is a sister agreement of WTO, World Trade Organization. India is a founding member of that, and it was implemented 1st January 1995. But India is a developing nations, got grace period of 10 years, so it was implemented in India and another developing nations from 1st January 2005. So that was the basic history of, or you can call a chronology of patenting systems across the globe. Let us try to find out patent timeline in India. All over the world, where there is a British colony, most of the rules, regulations, acts are actually influenced and impacted by the British laws. So India is no such exception. India's almost all rules, regulation and acts, even in modern India, is highly influenced by the Patent Act, by the British Act. So British Patent Act, you can easily follow. The year is 1856. That means it's a British Act and the British time. Second one, once again, it was influenced by the British Act, the Patent and the Design Act 1911, and finally, after got independence in 1947 and the 1950 as a republic, India established its own act. Obviously, it's highly influenced, almost 70% to 60% borrowed from the British Patent Act, the Patent Act 1970. Whatever we discuss over here in today, we'll be discussing based on our discussion will be primarily focused on this Patent Act 1970, and it was amended many a times, 1999, 2002, 2005 to comply with the TRIPS. As I told you, TRIPS is an international agreement. India is a founding member and India bounds to comply. If India doesn't comply with that rules and regulations, certainly India would not survive economically. And in today's world, no country, no country, even the United States of America, cannot survive in isolated manner because economic point of view for every nation's export and import and the all kinds of foreign transactions is very much important, and without economy no national economy can be driven. So this is very important, and it's a highly regulatory and the binding on India, as India is a member nations of the TRIPS. So what is a patent? I have already discussed. Patent is given to an inventor for a limited period of time, and in exchange of that he gets 20 years period of time protection. If anybody violates his patent right, he can directly go to the court, drag him to the court and get the all legal protections from the government. So that's all about the patent. Then what's a trade secret? Trade secret is a kind of thing why we are thinking about that trade secret. Why are trying to juxtapose patent and trade secret is like that. If you try to examine patent in a microscopic level, patent itself are technological information. Trade secret, if you consider, say for a any kind of trade secret, say for a very popular trade secret is a Coca-Cola. So that's our trade secret. So that trade secret, what is the basic difference between the patent or the trade secret? That means in the chapter of intellectual property rights, I discuss a case study of Coca-Cola. The Coca-Cola inventor John Pemberton submitted to the United States Patent and Trademark Office his magical liquid, what we call it, Coca-Cola. So this Coca-Cola as a patent, as a patented inventions. But within a 14 days, he came back and withdrew his applications because he thought once this secret, once this information is compromised, everything is compromised. And after that, say for that time it was a 14 years for which duration this patent was given. After 14 years, what would happen to my legal heirs? John Pemberton thought about it. So he tried to keep that secret forever within that family. So this is why patent and trade secret more or less same thing, but it differs from its protection point of view. In case of a violations of a patent, you can directly to go to the court, but in the trade secret, you cannot directly go to the court because it's kept within you. You have not shared with the society. Society did not get any benefit out of it. So this is why. So your society, that means a government, is not going to give you any kind of legal protections for that. So trade secret, the most important aspect of the trade secret is trade secret can be kept forever if the secret is not compromised. So what is a patent and what is the relations between the patent and the society? Patent itself, why government is giving a 20 years protections? There is obviously there is a rationale behind it, logic behind it. Patent as a social contract. Patent as an inventor is inventing something, is sharing with the society so that society can also improve based on his or her inventions. So society is taking his inventions for its own development, and in exchange of that, society is trying to protect his inventions for 20 years period of time. So it's a kind of social contract. If there is a violation, inventor can drag the violators to the court and government gives a protection. So let me discuss how can we get a patent. So what are the basic criteria to get at the patent? And these three criteria is what I am going to discuss. All over the world, it maintains that because after the harmonizations by the TRIPS, as I already discussed, TRIPS means is an acronym of a trade-related aspects of intellectual property rights. It's an international agreement that has been initiated and mooted and floated by the United Nations body. There's a WTO, World Trade Organization. India is a founding member, so it has already harmonized. Uh, so every country needs to comply, bound to comply. Three criteria are there to get a patent. First one is a novelty. Second one is an inventive step. Third one is a industrial applications. But if your invention somehow related to the biological material, DNA, RNA, fungi, virus, bacteria, something related to that you need to submit very small amount of that microorganism to an international depository authority. Earlier, India was not having any international depository authority, IDA. But right now, India has become a member of that Budapest Treaty, and based on that, there are two international depository authority in India. One is a IMT, Institute of Microbial Technology, and National Cell Center in the Pune. So, in addition to that, fulfilling these three criteria, if it is a biological specimen or biological patented invention, biological inventions, you need to submit this biological material in addition to the fulfilling all three criteria. So let me discuss this second one. This is the most confusing and the debated one. This is the inventive step. What is the inventive step? Or sometimes it is called non-obviousness. Let me tell you a very small example. What is the summations of 2 plus 2? It's the summations of 2 plus 2. Everyone says that 4. But if your answer is obvious, which is a 4, you are not going to patent. It needs to be 3, 5, 7, 1, which is not obvious. That means when you are speaking that summations of 2 plus 2 is not 4 or something else, that means there must have some creative spark inside. And that creative spark needs to be rewarded through the patenting system. And the third one is the industrial application. Indian Patent Office always speaks about these industrial applications of your inventions. But European Patent Office right now it's a compendium of 29 countries. Very recently Bulgaria and Romania have been included with that. So this European organizations, that means European Patent Office, EPO, they are much more futuristic in their approach. You need not to speak your industrial applications currently, of current innovations or inventions, whatever you have. What is important, you might say it's future application, future industrial application that will also do to grant a patent. So that could be also one of those three important criteria. So what is inventions as per IPA 1970? Indian Patent Act, as I told you, that is the basics of our today's discussions. Patent Act, everything is controlled, governed, and regulated by this act in India. Here, invention means, as per section 21J, a new product or a process involving an inventive step and capable of industrial application. It clearly mentions what can be called inventions as per Indian Patent Act 1970 in India. And what should be the inventive steps? Inventive steps means a feature of an invention that involves technical advance as compared to the existing knowledge or having economic significance or both, and that makes the inventions not obvious to a person skilled in the art. Section 21JA. So these are the legal aspects. So let us discuss basic rationale or the logic behind this patent. What we are doing, we have already discussed patent is a contract between the inventor and the society. That means in one hand the person, that means inventor is getting protection for 20 years period of time, and in exchange of that, that person or inventor needs to disclose so that society can be benefited out of his innovations or inventions. So there are two things are there. One is a protection, another one is a disclosure. I already told you India joined in the international community, especially with the TRIPS, and complied with the TRIPS Act and the regulations and the sections. And after that, right now, both product and process patents are allowed in inside. So let me clarify this thing. Product and process patents. Earlier there was only process patents allowed. But especially big or multinational pharmaceutical companies, they stressed the TRIPS, especially three developing countries, Brazil, South Africa, and India. Is a highly populous country, and they have objected that people from India, Brazil, and South Africa, they have violated patent rights, and they are incurring a huge loss, especially in the pharmaceutical sector. So, what they claimed that both product and process patents needs to be protected in all three countries and all developing countries. So, let me clear by giving one example. Say for a calpol. Calpol, we always have some calpol when we feel feverish, right? But what happens earlier life? What happens? Suppose there is a you are feeling feverish. What happens that you are feeling feverish, but you are taking crocin instead of calpol, Why are you taking crocins? Crocin can also give the same effect because it are also having the same ingredient. That's a paracetamol. It's a paracetamol. Paracetamol gives more or less the same kind of effect on the patient's body. Earlier life, India needs to go outside or where that particular molecule is available. If that molecule is not known to the inventors, they go to the laboratory, find out the molecule and come to India and try to produce this. It's called reverse engineering. That means we are not investing in the research and development. We are simply copying somebody's inventions. And this is why all these multinational companies objected highly to the international community so that they can implement both product and process patents in India, especially in India. India is a highly influential, especially in the analog production, especially in the pharmaceutical sector. So, what is the nature of the patent? Nature of the patent is a negative right. Why patent is a negative right? Why am I calling it a patent is a negative right? Because in the chapter of intellectual property, I told you that there are three kind of understanding: scientific, legal, and economic understanding. In the legal understanding, it is clearly said that patent is giving or any IP is giving right of alienation. That means if it is your property, like your flat, car, everything, when you are saying something like that, that means you are telling or something is embedded hidden in that sentence that don't use my car, don't use my flat without my permissions. So don't use my patent without my permission. And from that point of view, patent is a negative right. Otherwise, patent or any country's patent is given to the invention. That means that invention promotes the innovative structures or innovative ecosystem of that nation. So certainly it's a positive. At the same time, patent is a negative right because it was stopping others. It's an exclusive right that is given to the patentee or inventor. It's an intangible property, exclusive rights given to the inventor, time bound. As I already said, 20 years. And always remember, there is no international patent. Sometimes you will find some advertorial, and it's basically fraudulent informations, and it's a gimmick. Patent is given. In fact, almost all IPs are territorial. If your patent is given by Government of India, so your patent is valid only within India. If your patent is given or granted by United States Patent and Trademark Office, that means your patent is valid only within the US jurisdictions. So protections, when we are talking about the protection, how protection can be given to the inventors to his claims. So claims in a patent, because suppose you have invented something, innovated something, that means you likely to claim something from the government. This is my claim. I want to this, I want that kind of things. So there are two types of claims, primarily independent claim and a dependent claim. Independent claims are there, that is the main claim. You can call it the main claim. And the main claim, normally it is one or two. A dependent claim could be any number, but more or less 15 to 20, could be 15 to 20. So when you are disclosing or disclosing your information to the society, what are the forms by which you can disclose your information to the society? There are two technical terms. One technical term is called provisional specifications. Next one is a complete specification. Name clearly suggests that provisional means something is temporary, something is at a provisional. When suppose you are starting a project, research project, obviously, immediately you come up or somehow you anticipate some kind of patenting potentials in your research project. Immediately you visit patent office and apply to the patent office for your patent in anticipated patent, and it helps. I'll let you know why this date is important when you are applying to the patent office. And once you finish it, because you will get period of 12 months, or maximum grace period is 6 months, so taken together 18 months, maximum 18 months you can get after submission of the provisional specifications. You have to submit complete specification. Keeping aside all these technical terms, that means you are disclosing your invention to the society in the form of a provisional specification and a complete specification. That means you are completely disclosing your inventions to the society. That's important, because if anybody wants to verify, suppose you are claiming something XYZ, but that XYZ cannot be executed sitting in Germany, Hamburg, you are claiming from Kolkata, or vice versa, someone is claiming from Hamburg, Germany, that cannot be replicated, that cannot be done, reproduced in Kolkata. So you are not going to get a patent. It needs to be replicated, it needs to be reproduced. In the chapter of Introductions to Intellectual Property Rights, I have already discussed, you can refer to that. So, what are the rights that you can enjoy as a inventor or patentee? Authorized person, that means it's exclusive use. No person can use your patented inventions without your permissions. You have a sole right for making, using, selling. You can sell it because I already told you that it's a property. That means it's a very similar to your flat, car, land, anything. You can give it, you can donate it, you can rent it, whatever thing you want to do with your properties, you can do with your intellectual property. That means here is a case of a patent, or you can import the patented product also. So let me discuss a little bit on these components of the typical patent document: bibliographic information, second, text with claims, drawings. And when you are applying to the patent office, you should not give many inventions together in the same form. It's called unity of inventions. And unity of invention says that one inventions at a time in a single applications. So what are the bibliographic informations needs to be included over here? Country of publications, national patent classification, international patent classifications, title of the patent, abstract, inventor, applicant, applications number, serial number, date, and etc. etc. Priority date, and this is why priority date is important. I will let you know. Priority date. These are the main portions. Text with claims, object of the inventions, prior art. Here, prior art absolutely a technical term. Prior art means the prior knowledge. I told you the basic criteria is novelty. If it is already available anywhere in the world, you are not going to get a patent. It's a prior knowledge. Prior art means prior knowledge. Definitions and description of the inventions, you have to describe what are the purpose you are going to solve, what are the technical problem you are going to solve through your inventions. You have to describe it. An example with the supporting data and claims, defining the monopoly. Claims means you are telling to the world, you are telling to the society and the government, this is my inventions, and nobody can claim what I claimed. So that's you are claiming a monopoly. And most of the cases, if it is a mechanical patent, most of the cases drawing needs to be added over there. The different specifications, you can go through it. The different specification: 33 centimeters, 20.5 centimeters slice, 33. So these are the specifications, nothing else. So let me discuss about patent document and its parts. What are the patent documents and its parts? You can see it's international PCT based publications. Is a patent document, and publication date is given over here. First filing date, applicant, inventor, title, abstract, drawing because this is a mechanical device. He has described this mechanical device through his drawings over here. This is the patent document. And there is an international patent classification. I told you patent is given to the technological material, technological objects. So this is why it is given for different kinds of material which are connected with different fields and the disciplines. There are different 8 sections, 129 classes, 628 subclasses, 70,000 groups. What are the main classes? A is a human necessity, B is a performing operations, C chemistry, metallurgy, D textile, paper, E is a fixed constructions, F mechanical engineering, lighting, physics, electricity, such and such. So time matters. I told you first to file F to F in countries including India. But earlier, even 10 years back, first to invent FTI was in the USA, Philippines, and Canada. But after the harmonizations or inclusion in the memberships of the TRIPS, almost all countries in the world maintains and the practice F to F, first to file. And this is why priority date is important. There are many this intellectual property rights acts, that is the patent act never mentions what are patentable. They have said what are not patentable. Many things are not patentable in India: frivolous subject matter, contrary to well established natural laws, public order, morality. If you are making something, inventing something that are causing some harm to human life, plant life, you are not going to patent. Mere discovery of scientific principle, abstract theory, living things, non-living things, you are not going to get a patent. Any treatment of animals, plant or a part of a plant, no. But biological things, after the inclusions in the trees, now we are bound to provide the patent for the microorganisms of the biological processes. An algorithm that is given in the red color, you can easily find out. Algorithm or a computer program per se is not patentable, but yes, sometimes it can be given using some new kinds of claims and the new kinds of interpretations of that. Why patent information is important? To find out the latest trend in the technology and how to exploit those technology, possible collaborations, and identify the key trends in this particular field if you want to work or do carry out any research. Who can apply? Anybody can apply for a patent. Your legal attorney, that means first inventor, legal attorney, legal representative, or your joint inventors. Anybody can apply, or you can apply jointly. Patent filing and the stages of the patenting, you can directly apply. Government of India has given a online facility ipindia.nic, and in that case you need to have some digital signatures. And the filing, first you file to the patent office, Indian patent office located in Kolkata, and different cities are there. Formal examinations, prior art searching, and after that once again it is published by the Indian patent office. Once again is a thorough examinations by the patent office. It might be granted or refused, and whatever the decision comes out, you can go ahead with your oppositions if you are not satisfied with the decision of the Indian patent office. So what we have learned today, key takeaways, the fundamentals of the patent and the patenting systems, and how it can be implemented. If you think that you have invented something, have economic potential, you can also go and find out. And it also saves different technological trends in a country. So we have learned today the fundamentals of patent and patenting systems. Thank you. So when you are applying for the patent, yes, we discussed that patent can be applied. You can apply on your own. That means as a single person, as an Indian citizen, you can apply. You can also apply jointly with your friend or your co-inventors, true and first inventors assignee, or the legal representatives like that. Or assignee can be a natural person. Suppose I'm giving a practical example. You are working in a university or a research laboratory. When you are working in a laboratory or a university, for any kind of inventions, what you need some infrastructures that are laboratory manpower could be your research people, that means our project people, your students, your scholars, or anyone can be a co-inventor in a laboratory. Infrastructures, building infrastructures, electricity, and many such persons, that means in the form of infrastructures, university or laboratory is giving you, without which you will not be possibly without which you will not be able to invent. So Indian Patent Act 1970, there is a provision. That provision says work for hire provisions. If you apply directly while you are working in a laboratory as a government scientist or a university professors, you cannot directly go to apply to the patent office without adding your university or a research laboratory as a assignee, because assignee, that means a first applicant, your assignee will be first applicant, and you are simply the inventor, assignee the co-owner. So assignee is the first owner of your patent. So this is the provisions, or any kind of such violations is legally avoidable, should be avoided. Or if you do not want any kind of litigation, you should avoid it, because while you are applying to the patent office, you should be very careful about that, whether you are complying to the Indian Patent Act or not. Now the question comes that modus operandi. After your application, suppose you have invented something. Any patent has a commercial interest. Suppose you want to apply at the same time India as well as US as well as three countries in the Europe. Then how can you do that? Can you do that at the same time, or do it separately or any such other modus operandi for applying? Yes, if you are applying to only India, you can directly apply to Indian Patent Office via ipindia.nic in. I have already given that link. In addition to that, what you can do, we call it an international patent route. There is no international patent application. There is only international patent application. And why should you go for an international patent application? At the beginning of my lecture, I told you that the Paris Convention is a convention. India was a founding member of that conventions, and after that PCT conventions came possibly in 1998, and India was also the founding member. And what is the basic difference with the Paris Convention? If you apply via Paris Convention, you need to apply every country separately. So while you are applying to the countries, different countries separately, you have to provide fees for the several countries separately. That means you have to spend a lots of money on applications, patent application. Patent is obviously an expensive proposition, but right now Government of India has highly spiced its reduced its price for the promotions of the innovation in India and developing a creative ecosystem in India. But most of the countries, patent application is a very costly expension and expensive propositions. So seeing all the difficulties and barring especially for the problems of the inventors, frugal innovators, grassroots innovators, world community under the aegis of the WTO, they have developed this PCT. PCT means Paris, these are cooperation treaty, Paris Cooperation Treaty. So, on this cooperation treaty, under this cooperation treaty, what you need to do, instead of applying the different countries, you can apply through single window. So, these single window systems can save a lots of money. So, there is an opportunity, there is a possibility and options before you. You can apply via Paris Convention separately, if you think so, or you can directly apply via PCT. Suppose right now European nations is having on 29 countries. You want to apply 10 countries or 3 countries. As per your choice and preference, you can tick and you can apply. So in India, right now they have developed a new process for patent application and its examinations and final granting procedure, that is called the expedited procedure. And this through these expedited procedures, you can also get your patent within a very short period of time. Earlier, it used to be given 48 months. It's a very long period of time, but United States take 31 months. European nations more or less takes 30 months. So, so when you are applying a patent, maybe in India, maybe in other countries, you should go through this PCT route, whether you are opting for the PCT route, when you can apply for the direct single window route, or you can apply different routes. That means different windows for the different countries, and it will be a very expensive proposition. It's up to you, but these are the routes. But trust me, there is no international patent application, no patent. There is only patent applications, international patent application, that is international. So this is the patent filing and the stages of the patenting. So we have discussed the fundamentals of the patenting systems and the filing systems too. Thank you.